Companies Act 2016. An auditor needs to present a statement relating to financial statement with the registrar. In the statement, it states that whether a. the company has in the opinion kept proper accounting records and other books during the period covered by those accounts. b. the financial statements have been audited in accordance with this act. c. the auditor's report on the financial statements was made subject to any qualification, opinion under any applicable auditing standards or included any comments made under subsection 266(3). d. as at date to which the financial statement has been made up, the company appeared to have been able to meet its liabilities as and when the liabilities fall due. Section 263 Qualification of Company Auditor. Any person may apply to the minister charged with the responsibility for finance to be approved as a company auditor for the purposes of this act. Second, the minister may, if he satisfied that applicant is a good character and competent to perform the duties of an auditor under this act, upon payment of the prescribed fee, approve the applicant as a company auditor. Next, any approval granted by the minister under subsection 2, may be made subject to such limitations or conditions as he thinks he fit and may be revoked at any time by him by the service of a notice of revocation on the approved person. Every approval under this section including the renewal of approval of a company auditor shall be in force for a period of 2 years after the date of issue unless sooner revoked by the minister. The minister may delegate all or any of his power under this section to any person or body of person charged with the responsibility for the registration or control of accountant in Malaysia. Any person who is aggrieved with any decision of minister or with the decision of any person or body of person to whom such minister has delegated all or any of his power under this section may appeal to the court. For the purpose of this section, person means a chartered accountant as defined under Accountants Act 1967, Disqualification of Company Auditor. 1. A person shall not a. knowingly consent to be appointed as an auditor for any company. b. knowingly act as an auditor for any company. c. prepare any report for or on behalf of a company if, First, he is not an approved company auditor. Second, he is indebted to the company or corporation that is deemed to be related to that company in an amount exceeding around 25,000. Third, he is, or his spouse is an officer of the company. b. a partner, employer or employee of an officer of the company. c. a shareholder or his spouse is a shareholder of a corporation whose employee is an officer of the company. Next, he is responsible for the keeping of the register of members or debenture holders of the company. He is undischarged bankrupt within or outside Malaysia except with leave or court order. He has been convicted of any offence involving fraud or dishonesty punishable with imprisonment for 3 months or more. Duties of auditor. 1. Every auditor of a company shall report to the members on the financial statements and on the company's accounting and other records relating to those financial statements, and if he is a holding company should also report to the members on the consolidated financial statement. The report shall be a. in the case of a public company, laid before the company at its annual general meeting, or b. in the case of a private company. The report shall circulated to its members or laid before the company at a meeting of members. Next, in the report, the auditor shall state that, whether the financial statements are in his opinion properly drawn up. 1. So as to give a true and fair view of the matters to be dealt with in the financial statement and in the consolidated financial statements. 2. In accordance with this act so as to give a true and fair view of the company's affairs and 3. Such financial statements shall be made in accordance with the applicable approved accounting standards subject to any specifications, guidelines or regulations as may be issued by such authorities. In the case of consolidated financial statements, the names of subsidiaries, if any, of which he has not acted as auditor. Any defect or irregularity in the financial statements and any matter not set out in the financial statements without regard to which a true and fair view of the matters dealt with by the financial statements would not be obtained, and if he is not satisfied as to any matter referred to in paragraph A, B, or C, his reasons for not being so satisfied. 3. An auditor of a company shall have a duty to form an opinion to each of the following matters. A. Whether he has obtained all the information and explanations that he required. B. Whether proper accounting and other records, including registers, have been kept by the company. C. Whether the returns received from branch offices of the company adequate, and D. Whether the procedures and methods used by a holding company or a subsidiary were appropriate to the circumstances of the consolidation. Lastly, the auditor shall state in his report the particulars of any deficiency, failure or shortcoming of any matter referred to in this subsection. Powers of auditors. An auditor of a company has a right of access at all reasonable times to the accounting and other records, and is entitled to require from any officer of the company and any auditor of a related company such information and explanations as he desires for the purposes of audit. The auditor's report shall be attached to the financial statements or consolidated financial statements and to be read out before the general meeting of the company and shall be open for inspection by any member at any reasonable time. An auditor of a company or his agent authorized by him in writing is entitled to attend any general meeting which he attends on any part of the business of the meeting which concerns the auditor and his capacity as auditor. Appointment of auditor of private company. 1. A private company shall appoint an auditor for each financial year. 2. The registrar shall have the power to exempt any private company from the requirement determined by the registrar. 3. The board shall appoint an auditor of the company. A. In the case of newly incorporated companies, at least 30 days before the end of the period for the submission of the first financial statements to the registrar, or B. To fill a casual vacancy in the office of auditor. 4. The members shall appoint an auditor by ordinary resolution. A. In the case of subsequent years following the submission of its first financial statements, during the period for appointing auditors, or B. If the board fails to appoint an auditor. 5. An auditor of a private company shall only be appointed in accordance with the subsection 3, or 4. 6. For the purposes of subsection 4, the period of 30 days for appointing auditors means A. Before the end of the period allowed for the lodgment of the previous year financial statements with the registrar, or B. If the previous year financial statements were lodged earlier, before the day on which financial statements were lodged with the registrar. Appointment of auditor of public company. 1. An auditor of a public company shall be appointed for each financial year of the company. 2. The board shall appoint an auditor. A. At any time before the first annual general meeting of the company, or B. To fill casual vacancy in the office of the auditor. 3. Any auditor appointed under subsection 2 shall hold office until the conclusion of A. The first annual general meeting for the appointment, or B. The next annual general meeting for the appointment. 4. The members shall appoint an auditor by ordinary resolution. A. At the annual general meeting. B. If the company should have appointed an auditor at an annual general meeting but failed to do so, or C. If the board fails to appoint an auditor. 5. An auditor of a public company should only be appointed in accordance with subsection 2 or 4. 6. The company and every officer who breach this section commit an offense. Fixing of auditors' remuneration. 1. The remuneration of an auditor appointed by A. By the members of a company shall be fixed by the members by ordinary resolution or in such manner as the members may determine. B. By the board shall be fixed by the board, and if not so fixed, by the company, or C. By the registrar shall be fixed either by the registrar or the board, and if not so fixed, by the company. In this section, remuneration includes sums paid in respect of expenses and payment otherwise than cash, Resignation of auditor. 1. An auditor of a company may resign his office by giving a notice in writing to that effect to the company and its registered office. 2. A notice of resignation under subsection 1 shall bring the auditor's term of office to an end after 21 days from which the notice is given or from the date as may be specified in the notice. Notice of resignation of auditor to the registrar. 1. Where an auditor resigns his office, the company shall send a copy of the notice to the registrar within 7 days from the receiving a notice of resignation. 2. The company and every officer who contravened this section commit an offense, rights of resigning auditor of a public company. This section applies where the notice of resignation of an auditor of a public company is accompanied with a statement of the circumstances connected with his resignation. The auditor may give the notice of resignation referred to a signed requisition calling on the directors of the company to immediately call a general meeting of the company for the purposes of receiving and considering the explanation of the circumstances connected with his resignation as he may wish to place before the meeting. Next, the auditor may request the company to circulate a statement in writing not exceeding a reasonable length of the circumstances connected with the auditor's resignation to its members. A. Before the meeting called to auditor's requisition or B. Before any general meeting at which the auditor's term of office would otherwise have expired or at which it is proposed to fill the vacancy caused by his resignation. Furthermore, the company shall state the fact that the statement has been made in any notice of the meeting is or has been sent and send a copy of the statement to every member to whom notice has been sent. Next is the directors shall hold a general meeting within 28 days from the date of receipt of the notice of requisition. If the copy of statement is not sent, the auditor has right to require the statement to be read out at the meeting. The court may order the company's cost on an application to be paid in whole or in part by the auditor. Lastly, director who fails to take all reasonable action to call a meeting will commit an offense. Resolution to remove auditor from office. 1. The members of a company may remove an auditor from office at any time. A. By ordinary resolution at a general meeting and B. In accordance with Section 277. 2. This section shall not be taken as depriving the person removed of the compensation or damages payable to him in respect of the termination of his appointment as an auditor. 3. An auditor may not be removed from office before the expiration of his term of office except by resolution under this section. Special notice required for a resolution to remove auditor from office. A special notice shall be required for a resolution to remove an auditor from office at a general meeting of a company. Upon receipt of the special notice of such an intended resolution, the company shall immediately send a copy of the notice to the auditor proposed to be removed at the registrar. The auditor may make a representation in writing not exceeding a reasonable length to the company within 7 days from the receipt of this special notice and may request that a copy of the representation to be circulated by the company to every member of the company to whom notice of the meeting is sent. The auditor may require the representation to be read out at the meeting if the copy of representation is not sent.